Hi, all. Discussion was interesting and spirited in week 4. I do want to emphasize again that while I may be personally interested in your opinions and appreciate strategic use of outside research sources, your focus should be on demonstrating mastery of the materials in each week's readings, including where appropriate the dissents in each case. Which means if you disagree with a ruling, I expect you to be citing to what parts of the dissent you might agree with in criticizing the main decision. That said, I want to address the broader issue of how to approach seeming inconsistencies between rulings by the court. Among the justices and in popular discussion, there's often an attempt to find the threads that make the law as a whole consistent and seamless in reflecting what the Constitution means. But the dirty secret is the Constitution ends up meaning what 5 justices believe at any point in time. And while justices are often reluctant to explicitly overrule a previous decision, they often redefine the issues in such a way as to effectively make the earlier precedent meaningless for anything other than its original specific facts. If roughly 100,000 votes had been different in a handful of states in 2016, the Supreme Court would be saying the Constitution meant very different things this term, with a different justice in the swing position. Janus, for example, would have definitely come out the other way. And just as the rulings would be even more dramatically different if a handful of voters had shifted in Florida in 2000. The dissents you read in many cases would be what the Constitution meant with different political results. Similarly, you can't really appeal to the framers' intent to settle the matter for a number of reasons. First, the founders were a diverse bunch, and you have to then think about the intent of every legislator who voted for every subsequent constitutional amendment to say what the Constitution was intended to say. Second, if you invoke such framers' intent, you really have to accept the whole framework of understandings back then, i.e., women, blacks, people without property are unworthy to vote. Only 10% of the population had the right to vote on ratifying the Constitution, remember. The land of Native Americans could be appropriated without compensation, and their religion banned. The religion of slaves could be banned, and they could be forced to worship in Christian churches, whether they wished to or not, and so on. So, when thinking about Town of Greece versus Galloway, referenced in our readings, was the point that a number of states had official religions at the nation's founding, where Jews and Catholics were taxed to fund Protestant ministers' salaries, even as many of the states banned Jews and Catholics, and even some Protestant sects, from voting or serving in office. And to give the modern issue of hate speech prominent in Snyder v. Phelps a twist, before the Civil War, the government declared promoting abolition of slavery essentially a form of hate speech. And such pro-abolition speech was banned in multiple states, and by the federal government in various ways. Quote, states' rightist anti-abolitionist Senator John Calhoun argued that if you criticized slavery, you libeled the South and inflicted emotional injury. No petition to Congress promoting abolition would be accepted by the Congress, and the federal government actually blocked abolition literature from being mailed to southern states. Then after the Civil War, the radical Republicans during Reconstruction passed a law in 1875 requiring that trains and other public accommodations serve blacks and whites equally. Very far thinking and far forward. But it was struck down by the U.S. Supreme Court, which said that the law was unconstitutional in 1883 and Congress had no power to actually regulate who would ride or not ride on public accommodations. But having said that, in 1883, that the Constitution prohibited mandating desegregation in public transit, the Supreme Court 70 years later in 1956 would turn around and say that, in fact, the Constitution required racial desegregation in publicly provided transit vehicles. The point: there is no simple, usable past of constitutional precedents, since the court has engaged in a nearly endless sequence of reversals, with many of the historic decisions so repellent that the court basically pretends they never happened. Which is one reason I urge you to pay close attention to dissents, because they often contain links to alternative legal positions of the past that have been overruled by the decision's majority and may lay out markers for where the court may go in the future, if the partisan makeup of the court changes. One other note. A number of you were troubled by the court asserting in U.S. v. Alvarez that there was no ability to sanction untruthful speech under the First Amendment, an issue the court is increasingly dealing with in various commercial speech cases. And it's worth noting, in many commercial cases and during government investigations, the government does send people to jail for lies and fraud. See Paul Manafort and Michael Cohen as recent examples. A big issue currently might be if Facebook could be punished by the government for allowing untruthful speech to spread on its networks. And also note that in Lane v. Franks, the right of a public employee to testify in government proceedings was partly protected in the language of the decision because the speech was truthful. So truthfulness in speech does maintain some status under many statutes and legal precedents, a point that the dissent made in Alvarez. I'll also note that while many of you seem quite comfortable with the court abolishing patronage hiring and firing with Elrod v. Burns, one impact of that decision was to encourage political campaigns who could no longer reward volunteer campaign workers with jobs to instead seek financial contributions from wealthy individuals and business interests to support their elections. So the Supreme Court, a few years later, in Buckley v. Vallejo, 1976, began a line of cases leading up to the recent Citizens United case in 2010, decisions that have largely hobbled restrictions on campaign spending by the wealthy. So, elections have largely transitioned from a system where working class people were rewarded with government jobs and thus worked on those campaigns, and instead replaced by a system of politicians paying off corporate donors with policy goodies that in order to get their campaigns funded. This is a big shift, and nowhere was there a Democratic vote to shift our elections in such a massive way. Just fiat decisions by the Supreme Court and closely contested decisions within that court itself. Now, I won't say I hope that clears things up, since the point is that the contradictions many of you commented on are real, pervasive, and inevitable given the political disagreements that get reflected in struggles over who gets appointed to the court in the first place. For that reason, you should maintain an eye on the politics lying behind the decisions and dissents in the cases as much as the principles specifically articulated. But again, good discussion this week, and talk to you soon.